Just give me a moment. And Diana, which room did you say you were in? Okay, that's okay.
No, it is not okay. My apologies.
Oh, it's fine. We have not started yet.
Well, that's very kind of you, but that is not acceptable. My apologies.
Your Honor, for that outburst, can we please put a tracker on Hank Wilkins?
All right, so we can have Mr. Davis come down, please.
The record reflects that Zach Dunn is going to single wife female me.
I went to a COE where a guy that was talking, in a federal thing was talking about how his phone was a tracker. And he said, and he chose a random day. He said, what's scary about it is how boring my life is. I wouldn't go into any place interesting.
All right, we're going to go on the record. Court is calling 2022 CR 1227, State of Texas versus Anthony Lee Davis. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Kitty Brovinick for Mr. Davis.
And are you Mr. Davis? All right, you're going to need to speak up so that the court reporter can hear. All right. And just one moment, everyone. Let me go to the real time. Dana, could you do a test? Just write the word testing. All right, it's up. Thank you. All right, Mr. Davis, I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Anthony Lee Davis who's placed on community supervision in 2022 CR 1227 for the offense of evading arrest, detention with a vehicle on June 28, 2022 for a term of 7 years? Is that you? All right, state.
Violated condition number 14U on or about the 28th day of November 2023 in Bexar County, Texas. The defendant, Anthony Lee Davis, did then and there fail to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and/or supervision officer and/or the head of or authorized personnel of the following program. Parenting class, in violation of condition number 14U.
All right, to that, how do you plead? True or not true?
And we waive the other violations alleged in the motion, Your Honor.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to violation 14U, the court could find it true, grant the motion, and sentence you up to 7 years in prison and up to $1,000 fine? Knowing that, do you still wish to plead true to 14U? All right, you're whispering. Court will find 14U true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant on supervision, and amend conditions to include the state ISF cognitive treatment track, followed by ISP supervision and continue mental health care with CHCS or Be Well, Texas upon his return.
That's our agreement, Your Honor.
All right,
Your Honor, can I ask-
probation, just one moment. Is that the probation's recommendation? All right, Mr. Davis, you wanted to say something? Sure. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
I also have a.
State your name for the record.
Davis.
Yes. What did you want to say?
I also have an address of my sister's house, if I can go there and still get help with my.
Now, here's the thing. We've tried that. And you haven't followed through. So it appears that the only way you're going to follow through is if you're an inpatient. Now you have choices today, and I'm going to give you a choice. Sometimes I can give people choices, sometimes I cannot. So here's your choice. You can go to prison for 5 years, or either you can go to state ISF, and I'm going to order that you be on GPS. And you are not allowed to live with your mother because there's a no contact order in place. You're not allowed to live with your sister unless your sister submits a letter to the court or comes into the court and says that she wants you to live there. And even then, I may not allow you to live with her. You understand? Because a lot of people will be at the jail, they'll be at prison, they get out and they say, oh, this person wants me to live with them. And they're just assuming that because of the familiar relationship, that somebody is okay with them living with them. You understand? So what would you like to do? Do you want me to try to give you the help you need? Or do you want to go to prison? You go to prison, you get out of prison, you can do whatever you want to do.
Prison.
All right. So why have you not been following through on what I've been ordering for you to do?
Well, at first I had no contact order at my mom's house, so I wasn't able to stay there. So I was really homeless until I worked my way up to have a car. Then I was living out of my car, and the communication was just bad because they were trying to reach me through my mom, and me and my mom weren't even on.
Why don't you just go to probation? Probation has a physical office that you can go to. And I know that when people are on probation out of this court, I tell them if there's an issue with probation, they can always come back to the court. So you didn't come here.
When I was going to probation, and then I was doing the Center for Healthcare Services as well. So the Center for Healthcare Services lady was telling me not to report to my old probation officer. And so that was where the mix up happened. But I was going to my probations, like when I was supposed to report, I was showing up. That was just that one time that I didn't show up at the end, and it was just bad communication. They didn't reach out to me, they reached out to my mom.
All right, this is what the court is going to do. Court is going to deny the motion, alter and amend conditions to include ISF cognitive, GPS partial for any mental health treatment, waive fees, and you to follow through with Center for Healthcare Services, and also for Be Well. And there's still to be no contact with your mother. Now, what's going to end up happening? We can go off the record. This is what's going to end up happening. When I say no contact with your mother, once you are stabilized with your medications and you've shown the court that you are actually following through on your mental health issues, then I'll consider allowing you to have contact with your mother, not live with her, but have contact with her. Then ultimately, if things are still going well and she wants you to stay with her, then I will consider that. But now you are not in a position where you should be staying with anyone. Now you are in a position where you should have your mental health issues addressed. Otherwise, this probation is not going to end well for you. You understand? Is there anything else you need from the court to be successful? I'm sorry?
No.
All right. So I'm going to say this again. I've said it before. If there's an issue and you feel as though probation is not addressing that issue, you can always come back to the court. We are here. Do you understand?
She's saying that you know where the courthouse is. And if you can't figure out anything else, you show up at this court, they'll contact and they'll bring you in front of the judge. I know this sounds crazy. She actually will, well, I'm just telling you. So, because she's telling you there won't be any excuses. Or are we
Yes.
co-hosts here?
Yes.
Okay.
All right. Yes. And of course, I'm not here on Saturdays and Sundays, but throughout the week I am. All right. Probation, is there anything else he needs? All right. Good luck to you.
They're gonna send
yes.
you you'll wait about 4 weeks and you'll be sent to the treatment facility. You'll be there about 2 months.
Hello.
I don't know which individual to speak about. I want to state as well. Based on that, I think we're probably gonna bring
Yeah.
$20,000. I've explained the condition of the case.
All right. So because the jury is coming up, if you take that agreement to Judge Nahara, I'm sure he'll sign off on it.
Thank you. Judge.
Right.
We appreciate
Thank you.
it.
And do you need the case number or anything?
Yes.
All right. So they will, can you make her a copy of this? And so they'll give you a copy of this and a B page for them. And then they'll sign off on it. Then you can take it to Judge Nahara. All right. Thank you so much.
So he's good to go, Judge?
Yes. All right, before the jury comes in, I'm going to fill up my water.
They were just aligning them outside, Judge.
All right, thank you. No, Judge Nahara won't need to see him, I don't believe. Thank you.
You can go into that witness now.
Okay, so we have to chair over there for.
Oh, yeah, we get. On the witness.
Oh, Judge, you want? He can the witness stand, he can the chair on the side.
No, she, but you can put the chair on the side.
Yeah, no, not really.
Really? Isn't that kind of long? It's 12 days.
I can, oh, you prefer down there? Just saying. Judge, you wanted him on the witness stand or down here?
Oh, either way is fine.
Oh, so you don't want him on there.
Okay.
So it's the felony. It's still in the felony drug court evaluation is holding them up.
Yeah.
Okay. Check back in a day, too, I guess.
Okay,
Good
yeah.
to know. All right, thanks.
Yes. All right, everyone, please be seated.
Anyone who was here or?
If we can put him, sir, if you're okay with being behind the gate, and then we'll make sure you have your number 4 card.
Okay.
All right, thank you so much. When they made these courtrooms, they did not ask the people who worked here what would be the appropriate amount of room. I'm sure that happens at everybody's place of employment. They never ask the people who actually work at a facility what would be best. All right, everyone, good morning.
Good morning.
All right, you're the first group where we've had a jury trial and I've said good morning and you all are still wide awake and ready to go. Right. My name is Stephanie Boyd. I'm the judge of the 187th District Court. You are on the 4th floor in the 187th District Court. So where are you? All right, y'all, that's all jumbled. Okay, so let's do it this way. Which floor are you on? What's the court?
107.
Who's the judge?
Stephanie Boyd.
Now, I know what you're probably saying. We know where we are. Why would she ask such a thing? And the reason why I do that is because whenever we take a break, everyone has to leave the courtroom. And when I say everyone, I mean the jurors do. And we cannot start again until everyone is here. And believe it or not, sometimes people get lost and we will sit and wait. One time we had a juror who was down the hallway about to go into another jury selection. So I always say that because if you're ever lost, all you have to remember is 187th. There's only 187th court in all of Texas. Or either if you remember Judge Boyd, there's only one Judge Boyd in the entire courthouse. So someone will be able to direct you where you need to be. To my left, we have the court reporter. She is taking down everything that everybody says. That's her job. And I always said that if ever I was in a position to make somebody's job easy, that I would do my best to do that. So I want all of us to make her job as easy as possible, because it is a hard job when you think about it, because some people talk softly, some people talk fast, and it's hard for her to hear if people are talking softly and if people are talking fast. So if everyone will talk at the rate that I'm talking and talk at this tone, this loud, it'll make her job easy. So can everyone do that?
Yes.
Has everyone been able to hear me so far?
Yes.
Now, this is something I'm going to also ask you to do to make her job easy. Every jury panel we have had has failed, but I have faith that you all are going to be able to do it. So everyone in the box, raise your card, please. Everyone on this front row here, raise your card. Number 4, if you'll raise your card. Raise your card. Just the people I've told to raise their cards. All right. Anyone else, if you do not have your cards raised, in order for the court reporter to hear you, you'll need to stand. So will everyone be able to do that?
Yes.
All right. So if somebody whose number is not raised starts talking and they don't stand, I'm gonna need the neighbor to touch them and say, hey, we're trying to get an A here, so please stand. All right, you can lower your card. Now I'm gonna have the parties introduce themselves. This is a jury trial in the state of Texas versus Isaiah Thomas Verjus. So could I have the parties for the state, if you'll introduce yourself, please?
Hi guys, I'm Allie Jackson.
Hello, everyone. I'm Zach Dunn.
And for the defense?
Good morning, everyone. My name is Jessica Gonzalez.
Good morning, I'm Mario Morano.
And Mr. Verjus, if you'll introduce yourself?
Hello, everybody, I'm Isaiah Varyu.
All right. So the other thing is you'll probably notice people who will come through this door. They're coming through that door because they haven't read the sign that says, "We're in jury trial. Please do not come through this door." So they have nothing to do with this case. They just didn't read the sign on the outside of the door. People will come through this door and they may have items for me to sign. It has absolutely nothing to do with this case. I'm alternate presiding judge, so I may get some officers who may come to that door for me to sign documents. Again, it has nothing to do with this case. And sometimes we have interns and other people who want to see a jury trial, so they will come in to observe. Does everyone understand? Right. Now, in your hands, you have cards. Those cards have numbers on them. Whenever something applies to you, when either the state or myself or the defense are asking you questions, just raise your card. And then someone will call you by the number in your hand. If you have a question about something, please raise your card. All right? And sir, if you could remove your cap. Thank you. All right. In this case, the charges are indecency with a child contact and sexual assault of a child. And I'm going to come back and talk to you more about those type of charges. When I talk to you and when the state talks to you and the defense talk to you, they are going to be speaking to you in hypotheticals. None of them are allowed to talk to you about what they think the facts of this case is. Does everyone understand? So when you are answering questions, just know it's not about what people think the facts are in this case. You'll only get to know what people think the facts are in this case if you are on the jury panel. Does everyone understand?
Yeah.
Now I want to talk to you about an indictment because Mr. Verjue is here because he's been indicted. An indictment is not evidence of guilt. How many people here, and I'm going to have you practice raising your card. How many people here have ever had a traffic ticket? All right. So this tells me we have some horrible drivers in this courtroom right now. All right. I've had a traffic ticket before too. So when I got my traffic ticket, and I want to say I think I was 21 or 22. So that puts me about 24 right now. Okay. That's just, see, your laugh just like, oh my gosh, she's so intelligent to be here, right? So let's say you get a traffic ticket and the officer says you ran a red light. That's why they pulled you over. They say you ran a red light and they're giving you a ticket. Back in the day, they used to write it on a piece of paper and they tear off the piece of paper and give it to you. Now I think it's electronic or something. So when that officer is giving you a ticket and you accept that ticket, that's not you saying I ran a red light. That ticket is just to tell you, hey, I pulled you over. I'm saying you ran a red light. And guess what? To answer for me saying you ran a red light, you need to be at municipal court. If you want a trial, this is the day your trial will be. This is what you're charged with. It doesn't mean that you're guilty of running a red light. It doesn't mean you're saying you're guilty of running a red light. It's just a document, and the indictment is just in a document to let somebody know, hey, this is what we're charging you with. This is where you need to be, and this is where you can have your jury trial. Does everyone understand? So an indictment cannot be held by you in any regard whatsoever. It can't be considered as evidence of guilt. It's really just an instrument to tell somebody what they're charged with. Because guess what? How would you like to show up to a court and you don't know what people are charging you with, right? You don't want to show up at municipal court and they say, the ticket says you ran a red light and they're like, oh no, we've changed it. It's here for a yield sign. So indictments, not evidence of guilt, not evidence of anything. It's just whereby somebody is brought to a felony court to answer for what they're being accused of. Does everyone understand? Yes. Is there anyone who's going to hold it against Mr. Verjue because there's an indictment? All right. The next thing I want to talk to you about is certain rights everyone has who's charged with an offense. Everybody has a right to remain silent. I'm sure some of you have seen The Practice, Beretta, Mannix, Paper Chase. Nobody's seen that. Okay, that's odd. I see some gray hairs and they're natural. Thank you, 22. All right. So anyone, thank you, 48. I appreciate that. Everybody else don't know what they're missing. So everyone has a right to remain silent. What does that mean? That means that if you're charged with an offense, nobody can call you as a witness and say, hey, we're going to call you as a witness. Can't do that because under our rights, and everybody has the constitutional right not to testify. Does everyone understand? And you cannot hold it against someone if they decide not to testify. You cannot consider it. You can't be like on Bewitched with Mrs. Kravitz, like, I wonder what they be. No, you can't do any of that because you potentially will be on a jury panel. Now, if you're just walking down the street in the real world, you can always think about somebody not testifying. But when you're inside a courtroom, you are not to consider it or hold it against anyone. Does everyone understand? Is there anyone who will hold it against Mr. Raju if he decides not to testify? All right. And of course, there are many reasons why people wouldn't testify, right? I've been a defense attorney. I've been a prosecutor. Sometimes as a defense attorney, I would tell my client, state hasn't proved anything. You don't need to testify. It's not necessary. Sometimes I would have clients who would just be terrified of testifying because when you think about it, you're sitting on a witness stand and everybody's looking at you. And then you have some people who stutter, some people who have different speech impediments. So there are a host of reasons why people may not testify. But the key point is you cannot consider it. You cannot hold it against someone if they chose not to testify. Does everyone understand?
Yeah.
And I know sometimes people will say, well, if I were accused, I would want to get up and say something. Well, that's you. And until you are actually in a position, sometimes people change their mind once they're sitting in a seat and maybe their attorney has advised them to do certain things. So does everybody understand? Now, everyone is presumed to be innocent. So what does that mean? That means right now, if you had to vote whether or not Mr. Raju were guilty or not guilty of this offense, everybody should say not guilty. And you know why? Because you haven't heard anything and because he's presumed to be innocent. So since he's presumed to be innocent, you know what that means? That means that the state has to prove their case. Does everyone understand?
Yes.
The defense does not have to prove anything. And when I was in law school, the best way the professors would explain it to us, they would say, you can sit over there, you can do crossword puzzles, you can watch videos, you can go to sleep, you can do all of that. You know why? Because you don't have to prove anything. Now, do I expect people doing crossword puzzles or watching videos? Absolutely not. But the reason why I give you the example that our professors gave us is to let you know that the burden never shifts to the defense. Defense does not have to prove anything. The state has to prove it. And they have to prove it beyond a reasonable doubt. And you may ask yourself, what is beyond a reasonable doubt? When I graduated from law school, everyone had to know the definition of proof beyond a reasonable doubt. If you didn't know it, you felt like a failure. I knew it. I knew it forwards and backwards. I knew where to put the comma. I knew where to pause for dramatic effect. I knew where to put the exclamation mark. First jury trial I have, I use it. I was so proud of myself inside. Didn't show it outwardly, but I'm like, yeah. And then guess what? The next trial I had, there's no longer a definition for proof beyond a reasonable doubt. So when I was a defense attorney and prosecutor, I would explain it to people by telling them what it was not. So next door is the historic courthouse. That's the one with the green rooftop. They try civil cases over there. They have two burdens of proof. One of them is preponderance of the evidence. And it's more likely than not something happened. So if you're ever on a criminal jury trial and you're deliberating and you're saying to yourself, well, I think more likely than not this happened, you know you are not at the correct burden of proof, because that is not proof beyond a reasonable doubt. That's on the civil side. So remember that. The other burden of proof over there they have is what's called clear and convincing evidence. Clear and convincing evidence is what is needed when somebody wants to terminate your parental rights. They're saying you're not a good parent, you're a danger to this child. Legally, we're going to take away your right to be this child's parent. That's the highest burden they have on the civil side. Guess what? Proof beyond a reasonable doubt is higher than clear and convincing evidence. Does everyone understand? So neither the state nor the defense nor I can give you the definition of proof beyond a reasonable doubt because it no longer exists. Now, in a jury trial, there are two phases. First phase, people like to call it the innocence phase. That's really not what the phase is. The first phase is whether or not you find someone guilty or not guilty. It's not whether someone is innocent or not innocent. It's whether did the state prove their case or did they not prove their case. Now, if you find someone not guilty, there's no phase two. But if you were to find someone guilty, there is a phase two. People who are charged with criminal offenses must make an election or selection that if they were found guilty, who would they go to for punishment? Does everybody understand?
Yes.
And that must be done before jury selection. It isn't somebody saying, well, I'm guilty, so let me go to this person or let me go to that person for punishment. It's the law. They have to make a selection or election if they were found guilty. In this case, Mr. Berjou has decided that if he were found guilty, the jury would decide his punishment. Does everyone understand? Now, let's talk about range of punishment. In each of these counts, there are 4 counts. The range of punishment in each count is 2 to 20 years in prison, right? Now, that's a wide range because these are second-degree felonies. So when you think about it, you could potentially sentence someone, if you were to find them guilty, 2, 3, 4, 5, 6, 7, 8, 9, 10, all the way up to 20 years. Does everyone understand? And that's a wide range, right? And sometimes for these type of offenses, people are eligible for probation. So some cases, if you were to find someone guilty, but not sentence them more than 10 years, they could be eligible for probation if you so decide. None of you know anything about this trial because I was telling you everybody will speak on hypotheticals. So there are some cases where you may say, oh, I can see giving somebody probation for this type of case. Because when you think about it, sometimes you think about the age of the complainant and the age of the defendant, right? Because sometimes you have people who may be 16 years old and you may have a defendant who is 20. And you may say, I could see perhaps giving somebody 20 years for that. Let me see what the facts are of the case. Does everyone understand?
Yes.
And then there are sometimes you may say, no, I'm going to give this person 20. But in this case, nobody can ask you what you would give somebody because guess what? You don't have any facts. So what I need to know, is there anyone who would not be able to listen to facts for punishment? And I'm speaking hypothetical, not about this case. On a sexual assault case, can you listen to facts and apply those facts to punishment if you were to find somebody guilty? Is there anyone here who can't do that? Is there anyone here who can't consider the full range of punishment, bearing in mind that what that means is that you will be able to listen to facts and apply those facts to whatever punishment you would consider in a case? Does everybody understand?
Yes.
Is there anyone who will not be able to do that? All right. Next thing I want to talk to you about is what's called the one witness rule. One witness rule is this. The state will call a witness. Again, I'm speaking hypothetically. The witness could be Mother Teresa, but this witness is someone who's credible. That means that you believe them. It's not too dark. You know how sometimes you say, well, I'm listening to that witness, but it was dark outside. Maybe it was too dark for them to see. They wear glasses. They were not wearing glasses that night. Listen to my hypothetical very closely. There's one witness. Witness does not have a vision problem. It's not too dark. It was there is light enough for this witness to see. The witness is trustworthy. You believe that witness is trustworthy. That one witness, if you believe them, proves the state's case beyond a reasonable doubt. Does everybody follow me? Okay. And the question is going to be whether or not you would be able to convict somebody from that one witness. Does everybody understand my hypothetical? Don't add anything to my hypothetical. Don't take anything away. Now keep that hypothetical in your mind. And I'm going to give you another hypothetical. Let's say someone is in a parking lot. It's just that person walking in the parking lot. It's not dark, but there is nobody else around. They think they're the only person in that parking lot. Somebody comes out of nowhere. They see this person, and it's only them now and this other person in the parking lot. That person robs them, takes their items, and runs and leaves. The person in the parking lot, again, there's only that person and the person who robbed them. How many people think that that person's case should still come to court? Raise your card if you think they should still be able to file a report. Is there anyone here who thinks that that person should not be able to file a police report and say, hey, I was robbed? All right. So as you can see, sometimes there are offenses that are committed when there's only the person who's the complainant or the victim and the person who did it. That, in essence, is the one witness rule. So I go back to my hypothetical where a person comes to testify. You believe them, they're credible, and they say, this is what happened. I was in a parking lot, reaching into my purse to pull out my car keys. This person comes up to me, robs me, takes my car keys, takes my money, takes off running. I know the person who did it. I saw them very clearly. This is how tall the person was. This is their hair color. I see that person in the courtroom now. This is the person who did it. Is there anyone here who would not be able to find that person guilty? All right. Next, I want to talk to people about languages. I love languages. When I was in law school and when I was in graduate school and undergraduate, there are a lot of people who spoke a lot of different languages. I always thought it was beautiful. I'm originally from Louisiana, so I decided to take a language that I should have been taking, knowing that I was going to live out my life in Paris, which was French. So lo and behold, I ended up in San Antonio. And I should have listened to my friend and took Spanish when she was taking Spanish, but I'm like, no, I'm taking French. So is there anyone here, if you could raise your card, English is not your first language? All right. 31, 33, 45. All right, everyone, here's the test. 31. Yay. What's your first language?
My first what? I'm sorry.
Your first language.
My first language is Spanish.
Okay. Have you been able to understand everything?
Yes.
All right. How do you say hurry up in Spanish? Thank you. I know how to say hurry up in almost every language. I was just testing you. All right. Thank you. Number 33. What's your first language?
Spanish as well.
All right. Did she tell me how to say hurry up correctly?
Yes, you
But there's another way to say it, isn't it?
did. Apúrate, ándale.
Thank you. That's what everybody knows, underlay. All right. Have you been able to follow through on everything that's been said?
Yes, ma'am.
All right, thank you. 45. Yes, what's your first language? All right, have you been able to follow everything?
What?
Have you been able to understand everything? All right, what does that mean, the waving of the hand?
Más o menos, en English is so.
So?
Yeah.
All right, thank you. All right, is there anyone here who has any type of religious reason or some type of reason where you can't sit in judgment of others? Okay. Now, the next question I'm going to ask is about time constraints and travel arrangements. I'm expecting potentially for this case to conclude on Friday. At the latest, it may be Monday. This is what both the state and the defense have told me. So is there anyone here who has any time constraints or travel arrangements? You have tickets to, some place that's not refundable and you can't put them in my name. Is there anyone? Raise your card if there is a time constraint issue. And I'm going to tell you right now, I'm going to start calling out numbers. And once you hear me not scream and yell at anyone, don't then backtrack and finally raise your number. So over here, we have number 5, 10. All right. Raise your numbers high so I can see them, please. 30, 40, 42, 43, 54. See, number 18. See what you did there? All right. And you on the front row, you had your card raised too, or no?
He's so sorry.
Okay, 64 and 74. All right, number 5, what's your issue?
I had plans to leave in town tomorrow morning. It'll be long until
All right, where are you headed?
down south to Laredo.
All right, what are you doing in Laredo?
I'm guiding a hunting trip down there.
What are you all hunting?
Still deer seeds.
So how do you feel about Bambi? Bambi's mom.
Pretty good.
All right, number 10. Number 10? Yes, that's okay.
And I have a third and final job interview in Austin tomorrow morning at 10 a.m.
All right, so you've been interviewed twice before with them? So what type of job?
I'm a nurse.
Okay, awesome. My mom always said, if you got the interview, then you have the job. So you have the job. Okay. Number 18.
Well, I'm not traveling, but where I work, it's just me and another nurse, and she's gonna be leaving out of town on Friday.
And where is she going?
She's going to Florida,
All right.
so I don't know if that.
Okay.
Because that's just me and her.
All right. Thank you for letting us know. Number 30.
This isn't really a travel thing and it may not be eligible for what you said, but I'm on a night shift and it's just a very small team. So this is just polar opposite my usual schedule is the only thing. And it may cause just work complications if I'm not there for a long period, but other than that, that's it. I'm not sure if that's even eligible for what you're asking.
All right. Where do you work? What do you do?
I work IT.
Okay. All right. Thank you. Our computers here are always down. I'm just. All right. Number 40.
In the afternoons and evenings, I take care of my child, so I have to pick him up every day after school.
All right. What time do you pick them up?
5 o'clock.
And what time would you have to leave in order to pick them up by 5?
30.
4:30. All right. Thank you. Number 42.
Good morning, ma'am. I have a data and analytics summit on Monday morning in Austin that I need to host for the Veteran Health Association.
Okay. Are you all traveling together? Is it, Austin traffic is bad. You all could ride together. Okay. All right. And what time?
It's a week-long summit, ma'am.
Week-
So I have to be up there at 6 in the morning on Monday.
Okay. And that's on Monday.
That's correct.
All right. Thank you. Number 43.
My wife has reservations for this weekend for my daughter's birthday and the plans.
Reservations where?
I have to tell her I'm not sure. I don't know their plans, all of them. She just, all I know is that she has reservations.
Okay, where? Is it going to be in?
I don't know the plans.
Okay, you're just showing up. At your wedding, did you just have to show up?
My wife and daughter
Okay,
for her
And-
birthday.
all right, they want you there.
Uh,
Okay,
absolutely.
all right. Okay, awesome. Thanks for letting us know. And you say that's tomorrow,
This weekend.
this weekend. So do you even know if you'll be available on Monday? Or you all coming back on Monday, or you have no idea?
It's not a clear.
They have truly kept you in the dark. Tell them you need to know. All right, thank you. Oh, and by the way, how old will your daughter be?
She'll be 10.
Oh, well, tell her I said happy birthday or birth month, because I believe in celebrating the entire month.
Be happy to hear that.
All right. Number 54.
I have a work on Friday and Saturday at 4.
And what do you do?
I'm a prep cook.
Oh, where?
Velvet Taco, it's pretty good.
Oh, I've never been there. Where is it located?
South Bend, near the Palladium.
Okay. Number 64.
I have travel plans to Las Vegas, non-refundable.
You just threw that in. When are you going?
Las Vegas,
When?
Friday morning.
Are you going by yourself?
Group of people.
Okay, I don't want to get you in trouble. I'm just, asking. All right, number 74. Good morning. Oh, I'm sorry to hear that. All right, thank you so much. All right, anyone else? See, this is what I mean. Number 52.
Morning, I have to do a group test every 2 hours, starting today at 11:30.
All right, group tests every 2 hours.
My pregnancy, I got a higher, my blood test was high, 175, it has to be a 145.
Ah, okay, all right,
Yes.
all right, thank you. All right, number 15.
I have a client meeting on Friday, Judge, through the weekend.
All right, what type of work?
I'm an attorney,
All right, and what time is that meeting?
Friday morning early, outside Refugio, Texas,
All right, what time?
9 o'clock.
All right, thank you. Number 16.
Next two nights I work from 8 to 4 in the morning, and normally I'd give them up, but this month, one of my insurance carriers they pushed the commissions back till next month, and it's just a bad time for me to give up work shifts.
Okay. All right. So, ladies and gentlemen, I'm going to tell you 2 stories. Both stories are true. The first story is concerning my uncle. My uncle grew up in a small town, Grand Cane, Louisiana. My grandmother's firstborn child. Since then, both of them have passed. But my uncle was super intelligent. And so the teachers just kept moving him ahead to the next grade because they were like, there's nothing else we can teach you. We're going to move you forward to the next grade. So he ends up, going to graduate. And of course, his siblings, when they come behind him, because all the teachers in Grand Cane knew all of the students, they were telling them, we are expecting a lot of you out of you all because of your brother, who's super intelligent. So when he graduates, the Vietnam War breaks out. Now, he legally can't sign for himself because he's underage, because everybody keeps moving him up in class. So he goes to my grandmother and he tells her, there's really not going to be any work for me here. I only see a way out of this situation going into the military. So she had to sign for him to go to the military. And I know we're used to all this social media stuff, but for the young people, going to take you back a little bit. During my grandmother's time, television wasn't on 24/7. The TV cut off at a certain hour. The national anthem comes on. NBC, on a good day, if the weather's nice, maybe you can get NBC. But normally you couldn't get NBC, you'd have lines. And their phone number was 4 numbers. And to make a phone call, you'd have to pick up the phone, call the operator and tell her what 4 numbers you wanted. There wasn't a computer where you just write things. There was what people call now snail mail, where you have to write a letter. So she signed for my uncle to go to Vietnam. And that was back in the day. Nobody knew where Vietnam was because, let's face it, America, we're not the best place with students who think geography is very important, right? So nobody knew about Vietnam really. All she knew was she's signing up to send her firstborn to go off to war. Maybe he comes back, maybe he doesn't come back. Nobody knows. When they were shipping him off, they didn't give her an address and say, oh, this is where he's going to be in Vietnam. So she had to agree for him to go off, write a letter, and then wait for months for it to return. Didn't know if he was going to be okay or not. He ended up surviving Vietnam. But the reason why I tell you that is because that's a sacrifice. I think too often in this time period, we throw around the word sacrifice so easily. To me, that's a sacrifice. When people do jury duty, that's an inconvenience. Because when you think about it, the inconvenience is, guess what? Downtown has too many one-ways. You see a building, you're like, hey, if I could just turn left right here, the building's right there. Then you have to pay for parking. And it's like, hey, I'm doing you all a service. Why am I having to still pay for parking? I'm not in charge of that. But so it's all an inconvenience. But when you think about your country, what does the country ask for you? They're not drafting anybody. Guess what? The only thing they're asking for you is to serve on juries. And they're not even to ask you to serve monthly. I know some people who have been called up one time in the past 2-3 years, and they're not asking you to even serve every 2 months, every 3 months. So this and pay your taxes is all the country asks for you. And those are all inconveniences. So in order to have jury trials, we need jurors. And both the state and defense, you know what they're looking for? Somebody who's going to be fair. And what does fair mean? Fair means that when witnesses are called, you're able to listen to the evidence and make a decision on whether somebody's guilty or not guilty based upon what you hear in court. Everybody has something in their past that they wish maybe didn't happen to them. Everybody has some kind of trauma. Even Pollyanna had trauma in her past, right? Thank you. Not everybody's seen Pollyanna, but everybody has something going on in their past. Sometimes when you try cases and it's a assault case where somebody got beat up, everybody's like, oh, well, let me raise my card. I know somebody who's been beat up, or I've been beat up. Or a sex case. Oh, I know somebody who was charged with a sex offense, or either I was sexually abused. And I understand all the trauma involved in that. But the main question is not whether or not you've had something that's happened to you in your past. The main question that both the state and defense are going to be asking, really, when they say, can you be fair? It's whether or not you can sit in this trial and make a decision on whether Mr. Verjus is guilty or not guilty based upon the evidence that you hear in the courtroom. Does everybody understand? Is there anybody who will not be able to do that? Now, the other true story I'm going to tell you is about one of my friends from law school. She decided to do civil work. Civil attorneys, as civil attorneys, you're usually not in jury trial. On the criminal side, people are in jury trial or in court every single day. So she got called up for jury duty. And she said, Stephanie, I got called up for jury duty. Let's have lunch. I'm like, great, this will be fun. So we have lunch. And I asked her, how is jury selection going? And she's like, it's going fabulous. Now that I'm a judge, I'm like, how can it be fabulous? Because you're not in court with me. But so I say, why do you say it's fabulous? And she says, because it's like in law school. I got my head down. I'm on the back row. I'm not talking. And I start laughing. She's like, what's so funny? I'm like, I'm so excited because we're going to be having lunch all week. So the quickest way to be on a jury, honestly, is to be silent. And I tell people that true story because the state and the defense have this small window to talk to you to find out what your thoughts are and everything. Does everybody understand? All right. So is there anyone who needs a break? All right. If you ever need a break, number 28, that's okay. And 29. All right. So I'm going to give you all a break. And I'm going to need everybody back here by 11:25. Now, here's the thing. If you need to go to the restroom, wherever you see stairs, there's a restroom on either side. So if you see the restroom is crowded, just take the steps down. There's another restroom on either side. You find a stairwell, you will find a restroom. And which court are you in? All right. So leave the plastic cards behind, and you are more than welcome to leave your items behind. All right. And we'll see you back here at 11:25.
Unruly mob.
Let's bring them in if they're ready.
Where the hell is that?
We're putting
Hang
it
on,
in-
where is that?
We're putting them in order, Judge, because they're all
Okay.
over the place.
Guys, I will email you both.
You guys know where to sit now, right? Yes.
It's nice to know I was the only one that had to go like it. Out.
I didn't think I could tell. I was just-
Everyone, please be seated. All right, ladies and gentlemen, each side is going to have 30 minutes to speak with you. All right, State, are you prepared?
Yes, Your Honor.
All right, you may proceed.
Thank you, Judge. If please support the defense. Good morning, it's still morning, we haven't quite hit noon yet. Like I said earlier, my name is Allie Jackson. I'm the lead prosecutor on this case, and this is my partner, Zach Dunn. And then defense has also introduced themselves. Is there anybody here who knows any of us or anybody who's working here in this courtroom?
No.
Raise your card. Always want to double check, you never know. So before we kind of get into this, I have one more housekeeping thing. You may at times, especially if you make it onto the jury, you may see me or Zach or defense counsel on our phones. You're probably going to think we're being rude because you can't be on your phones, but I swear to you that we are not. Zach and I are wrangling witnesses and dealing with other matters, and Jessica also has witnesses and they have other matters that they may attend to. So if you see us on our phones, please don't think we're being rude. So we are here for Wadire or Wadir, depending on where people went to law school. It is basically what we call jury selection. That's a misnomer. It's actually more of a deselection process, which is why Judge said that those of you who are quiet are the most likely to end up on here. What we're doing is we're trying to see if there's any biases, prejudices, or anything that keeps you from being a fair and impartial jury or juror on this case. The more you speak up, the more reason we have to get rid of you. We want people who are fair and impartial on this case. I'm about to get into the indictment, which is what the charge is. So this is a sex case. You're gonna hear, and it always makes people uncomfortable. I've been in this unit for 5 years, so I'm very nonchalantly going to be saying things like penis, vagina, penetration. Don't think I'm being flippant. This is what we deal with all the time, but I know that you guys are gonna be uncomfortable, but we're gonna get through it together. So there are, first charge we're gonna be talking about is indecency with a child by contact. Now, think of this as kind of the checklist that Zach and I have to prove. We have to prove each and every element beyond a reasonable doubt. Defense doesn't have to do anything. This is our burden, we welcome it. So we have to prove that on or about a particular date, this defendant did intentionally and knowingly engage in sexual contact with Joe, this is a pseudonym in this case, a child younger than 17, by touching her breast, part of her genitals, and by causing her to touch his genitals, with the intent to arouse or gratify the sexual desire of any person. Next one is sexual assault of a child. On or about September 1st, 2020, the defendant did intentionally and knowingly cause the penetration of the sexual organ of Joe, a child younger than 17, who was not their spouse, by this defendant's sexual organ. Sounds like a lot. If you make it onto the jury, you're gonna have kind of a charge, you're gonna have something to read. All of this will make sense to you, but this just kind of get you familiar with what we're here to talk about. Now, one of the things you're gonna see on here is I said nothing about consent. In Texas, if a child is under the age of 17, they cannot consent. Period. I don't have to prove that there was a lack of consent. We'll get into this more in a moment. But it also means that when it's under 17, that this means it could be anywhere from a child who is, 3 years old, all the way up to 16. Now, if a child is under the age of 14, that's a separate higher charge. So keep in mind, kind of going into this, we're most likely talking about a child who could be 15, 14, 16 when this happened. Think of a teenager. Now, in the language that we have to prove, it's on or about this particular date. The law does not require us to prove an exact date. It simply must have occurred before a case was presented to the grand jury. Now, is there anybody here who can think of why we wouldn't have to prove an exact date when we're talking about a sexual assault of a child? Anybody have an idea? What if it happens more than once? You may not remember it. Does anyone here, who here raise your card if you have a child? Keep your hands up if they are a teenager or a little older. Do any of y'all keep your hands up if you think teenagers are really great with dates? Yeah, that's what I thought. Now, hearing that we don't have to prove an exact date, is there anyone who says, I get it, I understand that's the law, Allie, and I understand why it's the law, but I want an exact date. I'm gonna hold the state to my own burden, and I want you to prove an exact date. Is there anyone who feels that? Raise your hand. Cool. So, in the indecency count, you notice that we talked about sexual contact. Sexual contact is any touching by a person, including through the clothing of the anus, breast, or any part of the child. And it also includes any touching of the body part of the child, including through the clothing with the anus, breast, or any part of the genitals of a person. So this just means touching the vagina, touching the breast. This can be over the clothes, this can be under the clothes. It can be with their mouth, it can be with their hand. And you'll hear what's, if you're on this case, you're gonna hear what we're specifically talking about. Now, more about consent. They cannot consent under 17. Doesn't matter, they flirt. Doesn't matter if they send inappropriate text messages. Doesn't matter if they secretly arrange a rendezvous. Doesn't matter if they come on to the person. Adults know better, and adults are in charge. A child cannot consent. Now, we were all teenagers once, so I know that people can be a little uncomfortable with this. And so I need you to sit here and think about this whole consent thing, keeping in mind that we're most likely dealing with teenagers, 14, 15, 16. Is there anyone here who says, Allie, I understand that they cannot consent to have sex with someone. However, I will not feel comfortable if you do not show me that there was force or coercion or some sort of threat. If they didn't resist, I can't. Is there anyone here who says, Allie, I need you to prove that they did not consent and I cannot follow the law? And it's okay if you do, I just need you to raise your cards right now. So, Judge talked a little about beyond a reasonable doubt and how we have no definition. Like Judge, we can also tell you what beyond a reasonable doubt is not. It's not beyond all doubt. It's not 100% certainty. What is the only way you can know 100% that something happened? Juror number 6, what do you think? See it. You said see it. Raise your card. 38 said see it. Correct. If you saw it and you witnessed it, you know 100% it happened. And you're going to be here as our star witness. You're not going to be sitting on the jury deciding. And when we talk about possible, all possible doubt, just because something's possible doesn't mean it's reasonable. Say you guys were coming in here this morning, and I know it's not, but say when you came in this morning, skies were dark, there was a wind blowing in, and there'd been talk of rain. You managed to escape here after only 30 minutes. You walk outside, everything's wet. There's puddles, cars are wet, people are carrying umbrellas. What happened? It rained. Now, is it possible that someone decided, I don't like this courthouse, I don't like the people who work here, took a hose and just started spraying everything? Yeah, that's possible, but that's not reasonable. That's where I'm kind of going with that. My main thing is use your common sense. Everyone has it. Please just use it. Think of a case like putting together the pieces of a puzzle. Sometimes you may have all the pieces. Sometimes you may be missing a few pieces. Everyone's going to have their own idea of what all you want, what all is reasonable doubt to you. Everybody's an individual. To say there's a few pieces missing. Looking at this slide, who can tell me what this is a puzzle of? Again, are there pieces missing?
Yes.
Is there anyone here who says, no, that's not enough for me. I need to see all the pieces. I need it. Anyone here who doesn't think this is a puzzle of a gun? Cool. The main thing when you're evaluating the case and listening to the evidence is to ask yourself, do I have a doubt? Is it a reasonable doubt? And did it go to one of the elements that Zach and Allie had to prove? That is the key point. Now, we're all human. We all have a level that we want to get to in order to make a decision that would affect somebody's life. Because even if you gave a defendant probation, it is still affecting their life, and that's fair. So is there anyone here who says, I get it. I get what the law is. I get that beyond a reasonable doubt is the standard, but I need no doubt. Is there anyone here who would make us prove the offense beyond all possible doubt. Please raise your card. Alrighty. So, next thing is evidence. Who here has any idea or suggestions of what kind of evidence you expect to see in a case involving assault or sexual assault? Juror number 7, what is the evidence? Witness. Testimony is evidence, y'all. All evidence comes from the witness stand. From somebody testifying, somebody bringing in physical evidence. You get to sit up there and judge their credibility. Now, in cases like this, some people might expect medical evidence. Who here would kind of expect medical evidence in a sexual assault trial? Raise your hand. Most people. We all watch CSI. We all watch Law and Order. Now, is there any reason you can think of why there wouldn't be physical evidence? Number 54? A bath. Time elapsed. They could have bathed. There's not going to be any evidence. Anybody else? What if they outcried much later? Would there be any physical evidence if nothing was found out? No. Things happen. So there's not always. Number 48.
There's no passing of fluids.
There's no passing of fluids. Number 48. Correct. So there's not always going to be medical evidence. There's many reasons why. Now, hearing that, and this is also another fair thing, this is your personal decision. Is there anyone here who says, I understand why there may be reasons, there wouldn't be medical evidence, but if I do not have medical evidence, I cannot listen to this case. I require the state to bring medical evidence. Please raise your card. Right. Now, who here, again, raise your hand if you have kids. Most of us. Now, can you tell when your kid is lying? 13, 13 is very quick. How can you tell your child's lying?
Yes, by the way, the eye movement and the way they handle themselves.
Okay, eye movement, handling themselves. Number 11.
My wife tells me.
Your wife. Okay. Yeah. What are some other ways you can tell when your child's lying? Anyone else? Number 48.
Depends on what my daughter calls me, mom or mommy.
Oh, there you go. Word going. Number 7.
The head is down and can't look you in the eye.
Head is down, can't look you in the eye. Body language. 64.
Their mood.
Their mood. Yeah. 34.
Change of tone.
Change of tone. 67.
Inconsistency in stories.
Yes. We got demeanor, motive. I think you guys got everything. What they say, if there's anything that backs up their story, kind of what the circumstances are. Now, who here, who can be a victim of a case like this? Who here thinks anybody can be a victim of any type of? Yeah. Now, I would love if my victim and my witnesses was a bus full of nuns. That would be fantastic, but no one is perfect. Probably not even the nuns. But we just ask that you sit and listen to everybody and you decide who you believe. Now, Judge touched on this briefly with
Just 1 second. Yeah. Yeah, just one moment. State and defense, if you can come forward. All right, ladies and gentlemen, it appears that 26 is having an issue. And normally jury selection, everybody needs to stay together, but both the defense and the state have agreed that they'll continue with their voir dire. And then if they need to ask some more questions of juror number 26, they will be given the opportunity to do so. All right, state, you may continue.
Your judge touched on this with the one witness rule. So we know we're here talking about indecency with a child and sexual assault with a child. Where do these types of crimes occur?
Anywhere.
Anywhere? Do you think they occur where other people can see? No. No. They occur behind closed doors. The two people who are typically there are the abuser and the child. Makes sense. That's why Judge talked and kind of touched on the one witness rule. Now, technically, if the victim came in, testified, they could testify to every single thing that Zach and I had to prove. And we could technically put on a one witness trial if you believed that victim beyond all reasonable doubt. That doesn't necessarily mean that there's not other witnesses to be brought in. You know, there might be a police officer to come in to corroborate, hey, they made this account, the account's consistent, this is what we did. You know, there may be other people who did exams, you know, they're just kind of gathering evidence, but at the end of the day, there's only one person or two people really who know what happened. That's why we have the one witness rule, because that makes sense to everybody. Okay, is there anyone who says, that's great, but I'm gonna need a lot more than one witness to prove this case beyond a reasonable doubt, Ally? Please raise your card. Cool. Now, you know, we're here most likely talking about teenagers. Who here thinks that when a child has been sexually abused, all kids react the same way? No one does. How would you expect different kids to react to being abused and talking about it? Silent. Silent? Is that number two? Do you mean like not to say anything or not want to talk about it?
Yeah, not explaining anything that might have happened.
Okay, they're not gonna want to talk about it. Who here agrees with number two? They might not want to talk about it. We've got one, keep your cards up, but I say your number. It's most of you, but 1, 2, 3, 4, 5, 6, 7, 8, 10, 11, 12, 13, 14, 15. Actually, we're gonna stop right now. Raise your hand now if you didn't raise your hand. Raise your card if you didn't raise your hand. We got 51, okay, and 28. Much easier. Yeah. Do you think that all kids will testify the same?
No.
Now, juror number 2. Can you please tell me about the last time you had sex? How do you feel when I asked you that? About last month? Okay. How did you feel when I asked you that question?
Well, there's a lot of people here.
Yeah. 75 of your best friends. When I asked her that question number 1, how did you feel? Do you think maybe you're next? Yeah. How do you think a child's gonna feel talking about a time when they were sexually abused to a room full of their new best friends?
Very uncomfortable.
Very uncomfortable. Number 19? Who here agrees with number 19 that a child's gonna feel very uncomfortable? Most of y'all. Raise your hand if you didn't agree that it was gonna be uncomfortable. Okay. Yeah, it's an uncomfortable situation. So sometimes someone can look. How do kids look when they're uncomfortable? Like, what are the things that you can see and be like, oh, this child's uncomfortable? Number 5,
They look down, they're squeamish.
look down and squeamish. Anybody else?
Withdrawn.
Withdrawn, number 19. Yeah.
They might stutter,
Stutter, number
or they
48.
might continue blabbing.
Yeah, might just babble. Yeah.
They'll also have nightmares.
Nightmares.
They also squirm.
Squirm, what card? 38. They might squirm.
They might get depressed.
They could get depressed. Are you 54?
All right, so everyone, make sure you remember the rules.
That's the end. Who would you answer? They might, but 54 said they might get angry. Number 2? I forgot it. Number 5,
They don't want to be around the person that assaulted.
they don't want to be around the person that assaulted them. 64?
What they post on their Instagram or whatever they,
Yeah,
whatever social media that they have.
they might post about it. Yeah. All right. all different ways. Number 40,
They could change their routines.
change their routines. So those are all different things that you can look for in a child who's been abused. Now, I'm gonna ask a 2-answer question right now. Sit with it before you answer. Neither one of these is a wrong answer. Just trying to get some opinions here. Which do you think is more common? Number 1, a child makes up a completely false allegation of abuse. Or number 2, a child denies being abused when they actually were. Raise your hand if you are a number 1, you think it is more common for a child to completely make up a false allegation. Raise your card.
What if you don't know?
Number 38.
What if you don't know?
Okay, we'll get to the don't knows. Okay, what if you think it is more common for a child to deny being abused when they actually were? We got number 1, 2, 3, 5, 4, 6, 7. And you can put your cards after saying the number. 8, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 39, 40, 41, 42, 43, 45, 46, 47, 48, 49, 50, 51, 53, 54, 55, 56, 58, 59, 60, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, and 75. Raise your cards if you abstained from voting, which is totally fair. Number 38. And number 44. And number 14. And 57. Now, we're gonna get to any sort of biases about this later, but right now, raise your hand if you or someone close to you was a victim of sexual abuse. All right, keep your hands up right now. Lower your hand though, if that person outcried and told someone immediately. Lower your hand. Okay. Lower your hand if it took that person much longer to outcry. Now, keep your hands up if that person never told anyone. We have number 22, 42, 43, 49, and 50. Why don't children always tell immediately?
Because they think they're not gonna be believed.
Number 18, because they think they're not going to be believed. Number 2,
Because they're ashamed.
they're ashamed.
They think it's their fault.
They're too traumatized.
Too traumatized, that's number 38.
Correct.
Number 5 agrees. 24,
Embarrassed.
embarrassed.
Fearful.
Fearful, who was that? Number 29, okay. 27,
They'll get in trouble.
that they'll get in trouble. Number 36,
They just might not understand what happened.
they could not understand what happened. And then everybody in the back, whenever I call on your number, make sure you stand when you answer.
5 minutes.
Okay, thank you, Judge. I'm actually gonna skip forward a little, guys. Gotta get some stuff done. Now, this is a wild question. Raise your hand if you're a fan of sexual abuse. No one. No one is. No one wants to be in these types of cases, and I understand. Now, raise your hand, or your card rather, if you or a close friend or family member has been arrested or accused of sexual abuse. Raise your card. Number 3, 18, 21, 27, 29, 44, and 57. Now, those of you who just answered, because of that experience, Are you unable to be fair and impartial to both sides in this case? What I mean is, are you unable to take that experience or that knowledge, put it aside and listen to the facts that Zach and I present? Those of you who earlier raised your cards if you cannot be fair and impartial because of that experience. Number 10, 18, 44, 21, 57. Now, we just did this one a little ago, but is there anyone here who you or a close friend or loved one has been a victim of sexual abuse? Please raise your card. All right, 1, 3, 5, 6, 8, 10, 11, 12, 13, 18, 19, 20, 22, 27, 28, 30, 32, 34, 35, number 4, 39, 42, 41, 43, 44, 47, 48, 49, 51, 53, 56, 57, 58, 59, 60, 54, 62, 63, 64, 66, 67, 69, 71. Now, same thing that I just asked. Because of that experience, we need you to take that hat off, put it aside, and listen to the facts, because these facts are not your facts. They're not your friends and loved ones' facts. Is there anyone here who says, I get that, Allie, but even if I am ordered to, I cannot put that experience and knowledge aside and be fair and impartial in this case? Please raise your card. Number 10, 8, 11, 12, 18, 20, 42, 43, 44, 47, 48, 49, 51, 56, 57, 58, 60, and 61. All righty. I'm about to sit down. Is there anyone else? If there's something we haven't talked about, but you really think we need to know before we decide whether or not to have you on our jury, but you'd rather not share it with your 75 closest friends and you want to talk to us and the judge later, please raise your card. All right, oh, number 20 and number 16. Anyone else? 68, 60, and 51. 10, 12, 14, 5, everybody's going up now. 22, 32, 44, 48, and 56. Alrighty, I'm about to hit my time limit, so I'm going to hand it over to Ms. Gonzalez.
Right. Yes.
All right, good morning. Let's try that one more time because my stopwatch isn't working. Okay, never mind. I give up. Good morning.
Good morning.
Hey, how's everybody doing? Okay, so Ms. Jackson and Judge Boyd covered a lot of things. So I'm still gonna have the slides in here, but I don't necessarily need to go and talk about these topics. However, even though they covered a lot of stuff very thoroughly, there's still some questions I'm gonna wanna ask you guys. And just a heads up, I wanted to be a professor when I was in college. I like the teaching aspect, so I am going to be calling on some numbers to kind of get you guys talking. And let's not forget Judge Boyd's rule. If you're sitting back here, go ahead and stand up. Okay, so we already covered that. We're talking about who's going to be a good juror. Allie spoke about sometimes people have biases and prejudices, things in their own history that kind of makes them not a great juror. For instance, one of the examples that a lot of people like to give is Willie Nelson. Would Willie Nelson be a great juror on a possession of marijuana case? No, him and Snoop Dogg can go stand over in their corner and watch everything on their own, but they're not exactly the people we want or the state wants. I may want them, But the state may not want them to be able to judge whether or not a person broke a law for possessing marijuana. So we're here to have this conversation, and like I said, Judge Boyd talked about a lot, Ally talked about a lot, and I'm going to talk about a lot. But all we're asking right now is that you listen. What I'm asking you is that you listen and answer my questions honestly and fairly, okay? So the judge spoke a little bit, the constitutional rights, boilerplate, easy to remember. The right to remain silent, everybody's heard that. The right to an attorney, the right to a jury trial and a right to a fair trial, and the right to confront the witnesses. So I'm going to ask you my first survey question. You don't have to hold up your hands, but who's on trial today? Well, actually, I do want somebody to answer. Who's on trial today? Anybody have the answer?
Say it.
I'm sorry, juror number 5? What'd you say?
Gentleman over there.
Gentleman over here, Isaiah Varju. Anybody else agree with this, juror number 5? Everybody? Yeah? Yeah? Yes. Okay. So remember when Judge Boyd talked about the presumption of innocence? Presumption of innocence says, my client, as he sits here right now, he's innocent. He does not have to prove anything, but he's not the one that's necessarily on trial. What we're asking for the jury is to be able to decide whether or not the state of Texas has proven their case. As Ally talked about and as the judge talked about, it's beyond a reasonable doubt. The jury that we're going to be selecting to hear this evidence is solely here to listen to the state's case, listen to the evidence that has been presented by them, and the jury decides, do I believe that? Do I believe that? And furthermore, has the state shown evidence of each and every one of those elements? That's what we're here for. So what does the state have to prove to you? Do I have some teachers in here? Anybody? Okay, so when I say 5 W's and 1 H, what does that mean to you? Okay, go ahead, number 60.
Where, when, how.
Well, I feel like we're missing one. When? Who? So we get
Where, when, and why.
who? Everybody got that? So the state of Texas is gonna have to show who committed the crime. What, how, when. Okay, those are part of the elements, that charging document that Ms. Jackson had presented to you guys. Where did this happen? They have to show it happened in Bexar County, Texas. Why? Here's the thing. I like to call this the hidden why. The state of Texas does not have to prove why a crime happened. However, as the jurors, I'm going to be expecting you guys to be asking yourselves several questions as we go through it. Why? The first question I'm going to be talking to you about is why would a witness lie? Why? I mean, Ally was talking about that people will deny something or they'll make something up, but that's where the hidden why falls in there. So how does the jury judge the state's case? Anybody see this movie? Anybody? What's your number? Juror number 48? What's this movie? If you can stand up. Sorry, if you can stand up.
My cousin Vinny.
My Cousin Vinny. Has there anybody else that's seen My Cousin Vinny? Yeah? Okay. I love this movie. No surprise. That's a shocker. This is a great movie. And so what is Vinny, the attorney, doing with each one of the witnesses in that case or in that trial? Or that movie, I should say. What was he doing that was so effective? Juror number 48?
He was getting to what really happened. Don't make it up. Don't assume, just the facts.
Just the facts. Just the facts, ma'am, is something that my dad always liked to say. But in My Cousin Vinny, the state presents a case and they tell a little story. And if you just listen to that, it sounds like they proved their case. But when Vinny gets in there and he starts asking questions of each and every one of the witnesses, you start to see the case unravel. Is that a good explanation for My Cousin Vinny? Does everybody understand what I'm talking about?
Yes.
So in this type of case, because Ally spoke about the one witness rule, that's what we in this field call it, the one witness rule. But when you have one witness, the one thing about the one witness rule is you have to believe the witness. The person may come in and they may testify and they may give evidence of each and every one of those elements the state has to present in order to get a conviction. But when you're a juror, the law is going to tell you, as the jurors, you are the exclusive judges of the credibility of the witnesses and the facts proved. Okay, everybody with me so far? So this is why it's very important that Isaiah gets the right to confront the witnesses. Who here is on social media? Okay, who here can reach in their pocket or their purse right now or their jacket pocket and pull out their cell phone? Yeah. We live by cell phones, right? Social media, judge calls for a break. What are you out there doing? Anybody, juror number 27, what do you do?
On the phone.
On the phone. Juror number 11, is it 11? Juror number 11, would you agree with that?
Yes.
Okay, and I mean, would you agree that it's just adults that do this? Is it children? You said you have children, right? Do your children have cell phones?
Yes.
How old are they?
27, 20, and 16.
Okay, okay. So I'll come back to you in a second for that one. So who here has a child? Let me ask you this. Who here has teenagers? Okay, put your hands down if they don't have a cell phone. Did I say that the right way? Yeah. Put your hands down if they don't have a cell phone. Juror number 31? Does your child have a cell phone? Okay, you can put your hand on. Juror number 33?
Oh, I misunderstood.
I think I got it wrong too. Well, go ahead and. So my point is, everybody lives on social media these days, right? Where's the tech date IT guy? What was your number, sir?
30.
30? Okay, what do you do for work? Like for your job in general? When you said IT.
I just maintain software and systems. But that can be too technical. That's what I do.
Okay, anybody else have a job that they work in where it's very IT specific? Juror number 42, you said you're going to a data summit?
Yes, I'm a data and analytics strategist.
Okay, so do you analyze things on social media?
Yes, ma'am.
Okay, juror number 70?
I'm a software developer.
Software developer. Okay, so you really know about all the ins and outs of this stuff, right?
Yep.
Kind of? Okay. All right, so how can you tell a person is lying? We already kind of covered this. We talked about the difference between children, and I think Allie's point is sometimes when a child is up there to testify, it may give off the same signs as they're lying. Because when your child is lying, you're looking at something at their details, their body language, changes in stories. But if they're nervous, they may look to be the same way. So, but this is going to be very important, especially in this type of case. If there's a one witness, you're going to have to sit there as jurors and look at this witness and be able to make that judgment. Is this person telling me the truth? Because like Ali said, you weren't there. If you were there, you'd be up there testifying. So does anybody have a problem with being able to make that type of judgment on another person? Anybody? Okay. So how can you tell a witness is lying? Juror number 1. How can you tell a witness is lying? Or person is lying, I should say.
Stuttering.
Okay, juror number 2. Do you have anything?
Very nervous, uptight.
Okay, juror number 3.
Anxiety.
The story changes. Story changes. Juror number 4. How can you tell a witness is lying?
I don't know them. I don't know if I can tell if they're lying.
That is a really good point.
Know their traits and how they're.
Okay, so like I think it was juror number 3 that was saying, what about if their story's changing? Would that be a sign to you?
Because they're nervous because they're here in court.
Okay. Okay, so what if they told the story to other people outside, not just in the testimony? So would that play into it?
Yeah.
Okay. So there's a lot of things to be able to tell, even though because that's a very fair point, juror number 4. if you don't know the person, how will you be able to tell these things? Let me see, I think I come up to it in a little bit. So you remember I said the hidden why? You know, why would a witness lie? Sometimes a motive for why a person would lie ends up coming up in a trial. Let's skip ahead, police officers. I may go back to that in a second. Okay, actually, I'm gonna go back. So police officers, more than likely, police officers are not there when something happens, okay? So who here has law enforcement in their background or is law enforcement themselves? Juror number 27, juror number 49, 71, and 62. You guys can put your cards down. I'm sorry, juror number 5 also. So police officers are there. They're in our community in order to protect and serve, but they're also there to do an investigation. But just like all people, they can make mistakes. What happens if what somebody is telling them is a lie? Does that make it, just because a police officer repeats it, does that make it true because a police officer is repeating the lie? Juror number, what's your number, sir? 57. So that doesn't make it true, right? So police officers can also make mistakes themselves, correct? What are problems with an officer that does a selective investigation? Juror number 57, can you think of a problem? If an officer just focuses and just believes that one story, what sort of things can happen with that investigation?
It'd be biased, it'd be one-sided.
Okay, juror number 58, can you think of anything?
They do have like a lot of authority over the case.
I'm sorry.
Sorry, if you could stand up.
It might be biased since they have much more of the authority over the case. It seems a lot more real on someone's side compared to someone who's not being backed up by police.
Okay, juror number 59, can you think of something if an officer just focus in on one person?
Just make assumptions.
Assumptions.
Right.
So they could myth stuff, right? And then juror number 60, would you agree with that? Okay, juror number 48, did you have something to say?
Yes, might listen with their own opinion in developing, making assumptions, deciding if they care about the person involved or the person who supposedly did something.
Okay, so who here is okay with an officer making assumptions and having a biased investigation? Nobody? Okay, awesome. Who here wants an officer to do a thorough and complete investigation? Everybody. Thank you. Okay. So what happens is yes, there is a one witness rule. And yes, it is true. Most sexual assaults, most sexual abuse will just happen in a private room. It'll just happen when it's an accused person and an alleged victim. That is 100% true. I don't disagree with that. But if you're not there, you're not in that room, and you don't know the person, like juror number 4 was talking about, how is the state going to be able to prove to you beyond a reasonable doubt? That's ultimately one of the questions that I'm looking at that I want to talk to you guys about. So we take it outside of that room, okay? We start listening to the witness's story. What sort of details is this witness giving to the jury to be able to corroborate their story? And I believe Allie asked you, what sort of evidence would you expect in a sexual abuse case? Who here would like to see photographs? Raise your card. If they exist, would photographs help corroborate a story? Video. If videos exist, would that help corroborate a story? Okay. All right, so there are things that can be done in order to corroborate a story. Now, remember when I was talking about the cell phone, who lives by the cell phone? Okay, would a cell phone, evidence of a cell phone and information in the cell phone, would that possibly corroborate a story?
Yes.
Okay. There's computers now, we have cell phones, we have tablets. So yes, sexual abuse may happen behind closed doors, but there's other things that we can look at to be able to pull together and see did something happen? Does everybody agree with me on that? Okay. All right. So who remembers all the feelings of being a teenager? Raise your card. Yeah. If you, whether or not you're dealing with your own teenagers, you've dealt with your own teenagers, or you yourself remember what it was like when you're a teenager. I mean, is that anything anybody ever wants to go back and relive? Let's be fair. No. Because I don't know if you guys remember the movie The Breakfast Club. These were my favorite 4 quotes that come out as the themes of The Breakfast Club. I see me and I don't like what I see. I really don't. I hate it. I hate having to go along with everything my friends say. You do everything everyone tells you to do, and that is the problem. I could disappear forever and it wouldn't make any difference. Teenagers are kind of in this weird flux. They want to be seen. They want to get attention. They'll do anything to get attention. But on the other hand, they don't want anybody to look at them. They don't want anybody to pay attention to them. So it's kind of like this horrible, weird dynamic. And so, unfortunately, things do end up coming out. Allegations can end up coming out. There are times that people can end up making a statement, whether or not it's true or false, to be able to get attention. What I'm asking for the jury, for the members that do get selected on the panel, is that you just listen to all of the evidence. I don't want to come to the end of the trial and a jury panel looked at my client and said, yeah, he looks like a person who would abuse a child. So even though the state of Texas didn't prove it, because it was a very tough emotional case, I'm going to find this person guilty. Can everybody agree with me that they will hold the state of Texas to the high burden of proof of beyond a reasonable doubt? Does everybody? Okay. Does anybody know what I'm talking about when I say the snowball effect?
Oh, yeah.
Okay, what's the snowball effect? I know it just disappeared on you, but juror number 48, what's the snowball effect?
When one person says something, another person believes it, another person believes that person, another person believes maybe the first person or the second person, and it just keeps rolling and getting bigger and bigger.
And bigger and bigger and bigger. And I'm gonna go back, see if I can get it to come back again. See if you guys catch what happens. Sorry, there's a little bit of delay. But if you caught it, at the end, everything can just fall apart. That's what we're here to be able to analyze, is whether or not this is a true allegation or whether or not it's just something that kind of keeps rolling and rolling and rolling, and see what happens, okay? How do I prove a negative? Any of my data analysts know? Anybody know 42? How do I prove a negative?
You can't.
You can't. You can't. And that's why the Constitution of the United States says my client does not have to prove anything to a jury, because you cannot prove a negative. I can try to show you things. So the state is going to make an argument. They're going to say that my client committed a crime. I'm going to try to poke holes in their story, but I cannot come to you and prove a negative, because if something did not happen, I cannot prove that to you. But I love this movie, and it says, that's a negative, ghostwriter. The pattern is full. Okay, who would believe a child just because it's a child? I'm going to start over here. Anybody in the jury box that would believe a child just because they're a child? Okay, front row over here, juror number 18. Second row, third row, fourth row, juror number 40 and 42. Anybody in the last 2 rows? Okay, front row over here. Second row, juror number 64. Third row, fourth row, and fifth row. Okay. Similar question. Who would believe a victim just because they're saying they're a victim? Anybody in the jury box? Okay. First row, second row, third row, fourth row is juror number 40 again. Fifth row, sixth. Anybody on the left, right side? Can I cross-examine a recording or a witness statement or medical report?
No.
No, I mean, it's just impossible. And then the judge talked about it. Who, is there anybody who's gonna say, nope, with this type of case, I need to hear Isaiah's story? Anybody? I'm sorry, jury number 38 and juror number 46. Okay, juror number 16, juror number 18, juror number 30. Okay, anybody on the right-hand side? Juror number 58. Okay. Now, we did talk about guilt innocence. Judge covered it, but I do think that there was one point that I want to go and make sure that everybody understands. When we're talking about that range of punishment, if you get to this stage, this is the time to consider what happened during the alleged offense, but also what is going on with Isaiah. What is his background? What is his current situation? And what is his future? That's all the things that you're going to be considering when you're looking at punishing him. Now, given these charges, probation may be a option if the jury sentences Isaiah to 10 years or less. Does everybody understand what I mean by probation? Okay. So is there anybody who is going to say right now, knowing that this case involves sexual abuse of a child, I will not consider placing a person back in the community on probation? That is the question I'm asking.
Just one second. Let me pause.
Okay.
All right, ladies and gentlemen, you don't know any of the facts of this case, the alleged facts. Does everybody understand?
Yes.
Right. So when you talk about punishment, the question is whether or not you can consider the full range of punishment. For example, in some cases as this, a person may be eligible for probation. So the question is not whether you're going to give probation to somebody or give them 2 years or 3 years or 20 years. What it means is that you know that potentially somebody could have probation. Can you think of a case, a fact scenario where you would give somebody probation? Can you think of a fact scenario where you would give somebody 2, 3, 4, 5, 6, all the way up to 20 years? Does everybody understand?
Yes.
All right, you may continue.
Thank you. So my question to you is, the judge is correct. You're not, by answering this question, you're not saying I am going to give Isaiah probation. What I'm asking you is, will you consider giving him probation? So anybody that's sitting in this jury box, can you say now, I will not consider giving Isaiah probation? Anybody in the jury box? Do you have a question or?
Question.
Okay.
Is this, when you present that, is that, has the jury or the court said, yeah, we have found him guilty?
Yes, this is
Okay.
only after he has been convicted.
And ladies and gentlemen, it's not whether you can give him probation, because remember, this is all hypothetical, all right?
Correct.
Right. If you can give any person charged with the offense of sexually abusing a child, could you think of any example and give that person probation? Willing to consider it. Again, you're not giving it. You're willing to consider probation. Okay? You will not?
No.
Okay, juror number 5. Anybody else that agrees in the jury box with juror number 5? Juror number 14, juror number 1, juror number 8, juror number 12. Okay, in this front row, juror number 16, juror number 18, juror number 19, 21. Next row, 27, 28. Third row, fourth row, juror number 42. Fifth row is jurors number 46, 47, 48, 49, 50. Okay, last row, 51, 56. Front row right here is 58, 59, 60. Next row, 64, 63, 62.
All right, 5 minutes.
Anybody beyond? Okay. So I want to spend a little time talking about beyond a reasonable doubt. Okay, I'm gonna give you guys a little scenario. It may sound weird, but just go with me, okay? Who here has children? Multiple children, raise your hand. Juror number 35, I have not heard from you. So juror number 35, how many children do you have?
3,
3 children. What are their ages?
16, 12, and 2.
So perfect. I love it. Okay. So your 2-year-old, well, we'll add on just a little bit. Okay. So let's say your 5-year-old. One of your 2 children were 5 years old. Okay. So they're helping you make cookies in the kitchen. Okay. You guys are making chocolate chip cookies, waiting to have, it's after school, having chocolate chip cookies for dessert. And the whole time your little 5-year-old is saying, Dad, I want a cookie. And what are you going to say? No, you got to wait for after dinner. This is for dessert. We're not having cookies right now. So you finish making the cookies, you take them out of the oven, they're nice and warm, you put them on the cooling racks and they're sitting there cooling, and ding dong, your neighbor comes and rings the doorbell. Okay, so you step out of the kitchen and you go to the front door, you talk with your neighbor for a few minutes, and you come back and you analyze the kitchen. There's 2 cookies missing. There's a little bit of crumbs, there's a little bit of chocolate on your kid's mouth. And what do you say to your kid?
Do that.
Did you eat the cookie? And what does your child say? No, I didn't eat the cookie. You told me not to eat the cookie, so I did not eat the cookie. Who here believes that the child did not eat the cookie? I mean, come on. We all know the child ate the cookie. So then you ask them, well, if you didn't eat the cookie, who ate the cookie? Okay. So, I mean, they're going to come up with a million reasons. What happens when he says, you can go ahead and take a break. What happens when he says Cookie Monster ate the cookie?
That's right.
Juror number 29. Is that doubt? I mean, well, hold on. I mean, is it doubt? Aliens could have shown up from outer space. They could have taken the cookie. Anybody could have taken the cookie. Okay? We all know Cookie Monster loves cookies. So of course he came off of Sesame Street and he came and stole the cookie.
My dog ate the cookie.
Right. So the question becomes, what is reasonable? Because like the state and the judge said, it's not all possible doubt. It is what is a reasonable doubt. Okay. So what if your son says the dog ate the cookie? Okay, that's possible doubt. What if they point to one of the siblings and say, they were upstairs, they came downstairs, they grabbed a cookie, they didn't hear the law that we're not allowed to have the cookies, so they took the cookie back up to the room and they ate the cookies. Yes, ma'am. Sorry. So that's reasonable, okay? But what happens when you're watching TV later that night and there's a news story about how a man dressed up as Cookie Monster is breaking into houses and stealing cookies? So my question becomes, can an unreasonable doubt become reasonable?
Yes.
Okay. Yes, juror number 19, you agree with me?
Yes, ma'am.
Okay, everybody in the box, do you guys agree with me?
Yes.
An unreasonable doubt can become reasonable. Left side, you guys understand?
Yes.
Right side, everybody understands. Because that's what we're asking for, is did the state prove their case beyond a reasonable doubt? We want to make sure you're going to listen to all of the evidence that is presented. And evidence is not my questions, but my questions become their responses. Listen to what I've picked apart and say, after it's been picked apart and gone through and everybody dug through it, did the state go beyond a reasonable doubt? Here, you're looking at it, it's clear. They went yards ahead. But when it comes down to a snapshot, that's where we don't know. The state bears the burden to prove it beyond a reasonable doubt. And if you're still sitting back there in the jury room and you're saying, maybe it happened this way, it could have happened, it possibly happened, you just still don't know, that's where you're ultimately saying not guilty. Okay? Does everybody promise to follow the law? Okay, thank you.
All right, ladies and gentlemen, I'm gonna have you all step outside in the hallway. Make sure that you are back. If you decide to do a restroom break or something, make sure you are back no later than 12:50. That's 12:50. Please leave the cards behind. Take your personal items with you. And the people who are in the box, you're going to need to take your personal items with you. And we're going to call you back in at 12:50. Everyone, please rise for the jurors.
Leave the numbers behind, I'll call you.